Okay, ladies and gentlemen, thank you for being here. Like it's just before lunch, and I know it's a bit challenging before, we go and have some food. But it's a pleasure being in Lebanon, such a lovely city, and hosted by everyone here. The topic of our session here is the bank civil and criminal liability for facilitating fraud and money laundering. It's kind of a discussion between the different jurisdictions. And I will partly introduce, like the members of our panel. Then we're gonna start with one, like part talking about, like how things are in Lebanon. Then we're gonna open it for discussion on the panel. And to start off, I'd like to introduce Mr. Abdel Hafiz Mansour, who's the Secretary General of the Special Investigation Commission, the Lebanon Financial Intelligence Unit. And he can say a word about himself, like just in a second. Then next to him, we have John Oxenham, who's the ICC FRAUDNET representative for South Africa, co-founder and director of Norton Inc. And last but not least is Babajide Ogundipe, who's ICC FRAUDNET representative for Nigeria, co-founding partner Sofund Osakawa Ogundipe and Bilgori. Sorry for butchering the name of that. And just me, Walid Azzam, who's a partner at Hadafan Partners based in Dubai and who specializes in white-collar crime. Now, I'll pass it to my panelists to start like introducing themselves, and then Mr. Abdel Hafiz will give us, just a brief talk about, like how the situation is in Lebanon. Then we'll open it for discussion. So maybe we just by John and Babaji just introducing themselves, then Mr. Abdel Hafiz can start by saying his word.
Well, thank you very much, obviously, for the opportunity to speak on this panel. Just very briefly, I practice in regulatory law and obviously white-collar crime in South Africa. We've had the fortune of hosting one of these events in the past, and I spoke recently in Mumbai. I'm hoping to regale you with a lot of treasures from South Africa, which should hopefully enlighten some discussion. And yeah, from my perspective, it's an absolute pleasure to be in Beirut.
Yes, good afternoon, everyone. My name is Babajide Ogundipe. I'm a legal practitioner practicing in Lagos in Nigeria. My practice, I used to describe myself as a general commercial litigator, but Ed Davis, who's our executive director, says I should never say that, never say that. I'm an asset recovery lawyer, specialist asset recovery lawyer, the only one working in Nigeria. So that's what I do, but generally speaking, if you have litigation, you're chasing money, you need it recovered, someone owes you money, I'm the man you need to see in Lagos.
Thank you.
Thank you for this short introduction. My name is Abed Mansour. I'm the Secretary General for the Financial Intelligence Unit. Actually, I'm the Director of the Financial Intelligence Unit for Lebanon. And for our international colleagues, probably some may know me, I was the Vice Chair for the Egmont Group for the last 4 years. And my term ended just last June. I see the title of the conference. You have attended something which is extremely important, at the same time, super challenging. This is a very topical issue. Asset recovery is something that is really the ultimate objective of all regulators and crime fighting agencies. Because unless we deprive the criminals from the proceeds of crime, I think we have done maybe half of the job or less. And to tell you how challenging it is, and I think some of my colleagues here on the panel and over there, the asset recovery on cases worldwide, somebody would say some stats go around that it is less than 10% of the amounts of the cases, and I can I think, comfortably say it's less than 5%. So that tells you about the challenges in the asset recovery realm and how difficult it is. Certainly, as practitioners, some of you know about the challenges. It's basically the differences in laws in between jurisdictions and the difficulties even more on international cooperation in between jurisdictions. It's not easy really to process and pursue legally issues across borders. We know it as Financial Intelligence Unit. We operate in the area of intelligence and intelligence exchange, information exchange. And that also proves quite challenging because for some of you who have heard some statements on the FIUs of the world are not alike. So you cannot perceive them to be alike. If you know of the FIU in jurisdiction, you cannot perceive it to be the model. There are no two or even a few FIUs alike. Even within the European bloc, there could be some minor differences, but across the world, the differences are in capacities, capabilities, reach, and functionalities are quite different. And this is a big challenge also to us, because FIUs is the new guy or the new boy on the block. FIUs came into existence less than maybe with the issuance of the recommendations of the FATF. That's in 1990, and the Egmont Group came to existence in the mid-90s, and then it's gathering really some steam and trying to do some things work. But the FIUs, as I mentioned, they're not alike. And if FIUs have to function in principle as FATF standards say, they have to be they have to grab more power from two very important bodies. One is law enforcement, and one is judicial, because law enforcement traditionally been involved in the financial crime, intelligence gathering, and compilation of cases, and judicial, of course, that's their main realm, because FIUs need to have access to information, and in many countries, access to information is as I said, to law enforcement. And there is one important, I would go quickly to tell you one of the main challenges and reasons behind the lower rates in asset recovery. It's because of the difference in time from a case has been opened, identified, and strong suspicions of a criminality that has taken place until the time that the final judgment has been issued. And mind you, on judicial sector, you have to go through stages where you have to go through, first of all, the seizing of the asset, then you have to go through the confiscation of the asset, and the final stage is asset recovery. So there are different stages. And you can imagine how law process is pretty slow all over the world. So to reach the final stage of at least, not the final, maybe the initial stage of legal, judicial asset freezing is quite challenging. And by that time, if the assets are not there, you could have the criminals behind the bars, and you look at the assets, they have evaporated and gone elsewhere. So one important provision in the FATF recommendations is to take provisional measures. Provisional measures by the time, as early as possible, a suspicion on criminality has been identified. And some FIUs have this power. And it's not called seizing, but we call it freezing, because that's an administrative power. So the FIUs, as long as they lay their hands on a case, they can issue a freezing order. Some of them, I said, is less than half. The 156 FIUs that we have in the Egmont have this power. And some of them have it for 3 days, some for a week, some for longer periods. But the important thing is they have it in their jurisdiction for such a time which is enough to allow justice to lay their hand on the case and really turn the administrative freeze into a kind of a provisional Caesar. So having said this thing about the subject per se, I can go straight now to the subject of sanctions. And my FIU has also another role, an additional role, an additional capacity being a regulator, the money laundering regulator. And the fraud certainly is a predicate offense to money laundering. So all the money, illicit money emanating from fraud would fall within the jurisdiction and realm of the money laundering law, and obviously within the capacity that we can handle such cases and freeze money that is emanating from fraud. In Lebanon, we have quite the experience of cases. Actual fraud is one of the wider kind of crimes that are happening in the economy, and actually we receive a bigger number, wider number of reports coming from the reporting entities on criminal case. The Lebanese law, to run quickly to the stage, allows the regulators as well as the regulator in principle, that's the FIU as well as the Higher Banking Commission, to lay different kinds of sanctions, ranging from administrative, the lower level like warning letters, reprimand letters, other administrative sanctions that we as FIU can impose is the request for staff to be removed from their positions or actually to be removed out of the institution altogether. And this is a very powerful kind of an action or sanction. And finally, we have, of course, the financial sanctions, just like the other jurisdictions would impose. And we did actually practice these sanctions all the way through. We have imposed some sanctions. Of course, warning letters are issued more frequently, and then the removal of staff or changing of staff like compliance officers, branch managers, or other senior staff. This has happened, and this is happening. And also the financial sanctions. However, the financial sanctions have to go through another body within the financial sector, where we refer the case to the Higher Banking Commission, which look at the case and they can impose the financial sanctions. But this is possible under the Lebanese law, and it happens in a quite efficient way. When we talk about the personal liability, the sanctions, I would like to come back to the personal liability in banks to the officers. And this is a growing trend, because when sanctions are imposed, and you know the list of sanctions probably you're aware of from the Banque Centrale de Paris, I'm quoting names, but that's pretty widely known. Banque Centrale de Paris sanction was about $9 billion, HSBC was about $2 billion, and the chain goes on. When the sanctions are imposed, even with as high as $9 billion, and finally, who is paying that? It's the shareholders, it's the company. And many cases, the management is getting away with it. Now there is an increasing trend to put management and senior management per se into perspective and actually have them pursued or being for their acts. And this is the only, I think, more effective way of putting the management and really to account and holding them to account. And I think that's a very effective and more effective tool than actually the bigger sums of money. I think I'll stop here because there will be some questions thrown here and there, and I think my colleague panelists will also make the interventions in this panel. Thank you.
Thank you, Mr. Abdel Hafiz. This was really a very informative part of the session. Just to explain, I mean, we'd like this to be like, like a bit with the contribution of the audience if they want. So we will discuss some of the points, but we'd like to see your knowledge or any points that you're interested to make. So we wouldn't mind at all if you have any questions to stop us in the middle and ask. And just to kick things off, like to start this, we are like, most of us are lawyers who do asset tracing, who do like regulations and, try to like deal with the system as it is. So part of it is like, some of the question you will see we're addressing is really the reality on the ground of how things are. And the first thing that I look at, according to what we were talking now, Mr. Abdul Hafiz Mansour was talking about the freezing and how interesting that is, that it gives the ability for the financial, we call it financial information unit in the UAE, so, but it's very similar to financial investigation. And basically, it does give them the ability to just like immediately freeze, an account for 7 days, and then to investigate and see whether, this is something that includes money laundering or any other crime. And based on that, the other side can also object. For example, for us, there could be an objection. It has to be done through the relevant court. If the objection is defeated, they have to go and wait at least 3 months before they're able to file another objection. And just to see if like the situation changes on the ground, and to prevent from the central bank or the Security and Exchange from just withholding or stopping the funds indefinitely with no recourse. But I was wondering, either John or Babajide, do you have something similar, with the financial information unit or investigation unit and the freezing power in your jurisdictions?
Well, we have what we call the NFIU, the Nigerian Financial Intelligence Unit, which started life as a unit within the offices of the Economic and Financial Crimes Commission, which is a specialized financial crime enforcement agency. The fact that it was there caused a fair amount of trouble. Nigeria was heavily criticized for keeping the NFIU within an arm of law enforcement. So it's now been moved into the central bank. And yes, they do exercise powers to freeze assets. How they do so is shrouded in mystery, in my own personal opinion. And what we have seen is that the NFIU in Nigeria is frequently used as a tool by government to stop perceived opponents from dealing with assets. We have a situation where the Attorney General, about 18 months ago, produced a list of people against whom predominantly money laundering cases were pending. And on the list, Attorney General was empowered to stop assets from being dissipated. And as a result of just being on that list, people started to find that their personal accounts were frozen, accounts of companies in which they had either signing powers or shares were frozen, and things of that nature occurred. So we didn't know who to proceed against because the NFIU didn't say anything. It was the Attorney General who said that you can't do it. And you go to the Attorney General and say, why is this thing? He says, oh, NFIU said it. So, and NFIU is a division now in the central bank, so it's confusion. Most people have litigated. We've tried to resolve it by administrative processes.
Okay,
Sure.
John?
Just very quickly, excuse me, very quickly from a South African perspective, I think there are agencies which are dedicated in that regard. Just to go through the Financial Intelligence Center, which is a very robust organization. I think Professor Ryder was talking about the difficulty of tracing the number of transactions, both private and corporate. I think we've got a very, very transparent and robust system in South Africa, and it's generally housed underneath the South African Reserve Bank, which is also a noted bulwark against corrupt activities, and in particular money laundering. But in relation to the actual mechanics to go about from a freezing perspective, we've got a dedicated asset forfeiture unit, which increasingly is becoming more robust. I think we went through a period of some difficulty through the previous presidency. I spoke about that at length during the Mumbai conference. We certainly have light at the end of the tunnel. That asset forfeiture unit sits beneath the National Prosecuting Authority. There have been significant positional changes which have resulted in more robust activity. And more recently, I think I spoke at length about a rather infamous family in South Africa which has been very robust in relation to engaging in these activities, who now have been sanctioned by the US government at the request of South Africa. And I think that's going to spearhead a lot of activity going forward from our perspective. So we do, from a notification perspective, it's by way of court application. So parties who would be involved or embroiled in that would then have the ability to either challenge it before the High Court or be involved before the High Court.
Okay. I mean, I am aware that we're a bit behind time, so I mean, we'll have to cut that a bit short. But I mean, just for my next question, you know, like to address that, like, I mean, are banks strictly liable for money laundering if committed by their employees, even if it proved that they have adequate measures? And I will put the question first, you know, to Mr. Abdel Hafiz, you know, like how are things in Lebanon? I mean, if the bank discovered that the employee has committed money laundering offenses, is the bank itself liable, or can the bank say, look, I've taken every single measure to stop, I have done internal reviews, I've done everything, but it's the employee who did this on purpose? How does the law address this?
I thought for a while you were asking the employee per se and as a person, on a personal basis, but being part of the bank, then it's the bank. There is no separation between the bank liability and its employees. So the bank has the responsibility to have enforced policies, systems, and procedures that are compliant with the anti-money laundering and countering terrorism financing regulations. And there are flaws, and that's his problem. And the bank, of course, will be held accountable. So there is no really difference here in between the two.
How about in the other two jurisdictions?
Sure. Well, so from a South African perspective, absolutely. And we've got some very salacious examples of what's been happening of late. There was a renowned bank, a local bank called the VBS Bank, which is embroiled in significant money laundering and looting issues and significant corrupt activities. But to answer your question, I think it goes further than even the bank's employee and their employees themselves. When I spoke last in Mumbai about what had been taking place in the broader realm of state capture, this case relates specifically to a bank, a local bank. The directors themselves were highly involved, writing fictitious home loans to themselves in an effort to try and remove money from the bank. And the unfortunate reality in relation to this case is that the majority of the shareholders of the bank, I wouldn't say shareholders, but depositors in the bank, were indigenous people within South Africa of poor means. And so it's a significant scandal. But from a prosecution perspective and from a liability perspective, the directors of the bank have all been brought before the relevant agencies. And as I say, not just them, but also the auditors who were advising in relation to the number of the transactions have now been brought before the relevant authorities. And so it's a significant matter beyond just the issue of state capture that South Africa has been embroiled in for so many years. But from an asset recovery perspective, I think it's going to pose some unique issues and challenges. So, yeah, absolutely, bank employees very much liable, bank directors all the way to the board representatives. The government had a significant shareholding in this particular bank. They're also on the line from an investment corporation perspective.
In Nigeria, it's a common law jurisdiction. So bank employees, subject to the facts of the case, would be personally liable. The banks themselves could be vicariously liable, all depends. But what, as a matter of practice, one observes in Nigeria is that banks very, very rarely get prosecuted for money laundering. The worst that will happen to a bank in a money laundering situation is that if an individual is being prosecuted, the bank will be asked to provide witnesses so that they can get a prosecution. Banks themselves rarely get prosecuted, and whether they get sanctioned by the central bank is something of a mystery, because the fact of or not of banks being sanctioned is rarely made public, so we don't know.
Okay. I mean, I'm aware that we're really running out of time and we'd have to stop that session. So we're going to put like one final question that we'd have to go, and I get to pick since I have the microphone. And I would say like the concept of whistleblowing, it is much more developed in the Western world. I can tell you that it's developing a bit in the United Arab Emirates. We have whistleblowing protection in the criminal code, and recently in the new money laundering law, they've added certain protection and certain incentives, but the incentives are more like protection for the whistleblower more than financial incentives. And I was wondering if you can give me like any insight of how whistleblowing protection and incentives are in any of the jurisdictions. I mean, we'll just start here from Mr. Abdel Hafiz, if there is anything on that.
Yeah, certainly, in our case, the whistleblowing is, excuse me, will be part of the anti-corruption law, which is currently in the making. And there will be an adjoining law as well for the protection of the whistleblowers. There are two actual laws, but they're not part of the money laundering law. Money laundering law is a total reflection of the FATF recommendations and the requirements. Whistleblowing is more will be covered under the corruption bouquet of laws.
So from the South African perspective, yeah, we do. We've got a specific piece of legislation called the Protectors Disclosures Act. I think it's been relatively well utilized. I think the unfortunate issue from a South African perspective is there's no financial incentive for a whistleblower to come forward because they're not compensated. I know, as you say, it's a lot more developed in other jurisdictions, particularly the US. But what we've seen of late, and I did discuss it very, very briefly because it was at its inception when I spoke in Mumbai, is we've had a number of commissions of inquiry, most particularly the one which goes into state capture, which has dealt with a number of the institutions in South Africa which were captured by an infamous family as well as certain government departments, not necessarily government departments, but members within those. And through that process, a number of parties have come through a fairly well-protected regime in terms of the inquiry itself and being able to give a lot of evidence. So although the act itself or the legislative instrument is not often utilized, what we're seeing, particularly from an ability to engage in a robust forum and a somewhat protected forum, is a lot of information is coming forward by parties who proactively engage and come forward of their own accord, and that's through these commissions of inquiry.
In Nigeria, we don't have any single piece of legislation which provides for comprehensive whistleblower protection. The Securities and Exchange Commission have regulations that deal with whistleblowers in publicly quoted companies. About 18 months, 2 years ago, the Nigerian government came up with a policy, just a policy, under which they would, in certain instances, reward whistleblowers whose information succeeded in recovery of money or assets for the government. The value of the reward isn't indicated. They said they will enter into negotiations with you. Your identity is protected. And again, as with so many things in Nigeria, it's somewhat opaque. We don't know how many people have taken advantage of this regulation. We don't know how much the government has paid out. And the one instance that did come to light, there was even a dispute between whistleblowers as to who actually blew the whistle and who was entitled to collect the money. Up till now, I don't know what the outcome of that dispute was.
Settled by swords at dawn.
Thank you, Babajide. I think because it's now time really that we have to go for lunch, we'll have to adjourn that session. I would like to thank you all the panelists and especially Mr. Abdel Hafiz Mansour for coming and joining us in this panel. And I think maybe lunch will start like shortly outside somewhere. Okay. Thank you.